A New Jersey last will and testament is essential for ensuring your loved ones inherit the intended property and assets. Best of all, wills can often be created without hiring an expensive attorney or undergoing any complicated legal procedure. In this video, we'll go over the importance of wills and what happens when one isn't made, what's included in wills, legal requirements in New Jersey, and how and where to create an official will. First, let's begin by discussing wills and their importance. A last will and testament, commonly known as a will, is a legal document that provides instructions on how to distribute an individual's property and assets after their death. The person to whom the will belongs, known as the testator, can name beneficiaries who will inherit all or a portion of their estate. Usually these beneficiaries are spouses, children, and blood relatives, but they can be any person or entity the testator chooses. Now, what occurs if no will is left? A person who passes away without a will in New Jersey essentially loses control of who inherits their property. Instead, state succession laws determine how the deceased assets are managed. The deceased estate usually transfers to their spouse or any children in these instances, but it differs from case to case. Leaving one's property in the hands of the state can cause loved ones to contest the decisions made by the courts when distributing the estate. Unfortunately, this can lead to drawn-out court disputes. Therefore, it's highly recommended all adults make a will, especially those who are elderly or facing serious medical conditions. Fortunately, making a clear will is typically easy and it can be accomplished without an expensive attorney required. A person of sound mind can draft a will in New Jersey with the following information on the document: their full name and residing address, the information of their personal representative, also known as the executor, who will distribute the assets accordingly, the names of all beneficiaries, and a thorough list of the property each shall receive, any additional terms and conditions, and the signatures of the testator and 2 witness signatures. Lastly, let's briefly review legal requirements in New Jersey. Wills in New Jersey must be signed by the testator in the presence of 2 or more credible witnesses. Both witnesses must also sign the document after attesting the testator's signature. Though optional, it is recommended that both witnesses be disinterested parties. Disinterested parties are individuals who do not stand to personally benefit from the will or receive a share of the testator's estate. Once all parties have signed, the document will be legally binding, unless otherwise revoked or revised. Several copies can be made and given to trusted individuals for safekeeping. We're eForms, the biggest database of legal documents. We have created state-specific last will and testament templates specifically designed for New Jersey that are quick and easy to fill out. Our software generates an official document after you select your desired will instructions and name all of your beneficiaries. Click on the link below to begin creating your will. And don't forget to like and subscribe for more daily videos.